He wasn't a man of power. He shelved it quietly among the law books. The library on Main Street was a narrow, honeyed room of high windows and steady light, a place where lives were measured not by names on brass plates, but by the careful turning of pages. In winter, it smelled of lemon oil and coal smoke, and in that smell, on a late January evening, 2 lives crossed like brief footnotes in a long book. The man who needed the books walked in like a man who had been taught, at some cost, how to be invisible. His boots scuffed the threshold. His coat, though mended, had a straight, honest line to it. When he pushed open the heavy door and stepped into the warm hush, the clerk at the desk looked up over the rim of a ledger and saw a face the town had learned to look away from, the face of a man who once served time. He could have been any age between 20 and 40. His hair had been cut close to the scalp in the prison yard, and his hands still bore the slight calluses of someone who had learned to work hard for his survival. His name, to the town, was a sentence, spoken in whispers at taverns, in curt nods from shopkeepers. It mattered less what he'd done, and more that the papers had printed it and the people had bookmarked it. The librarian's name was Elias Harrow. He was lean as a rule of wood, with shoulder blades like pages and a voice that tended toward understatement. He wore little spectacles on a cord and a cardigan that had once been a dark blue and was now the color of well-read paperbacks. Elias had the air of a man who preferred the company of facts and footnotes. He kept his life tidy and private, and believed, with the quiet zeal of someone who has seen the long reach of a single page, that a book ought to be judged by its content rather than its cover. Elias noticed the man before the town's habit could chime in with judgment. He noticed the way the man's hands hovered over the newel of the stair, the way he inhaled the warmth as if it were a thing scarce as good luck. For a few seconds, the library was nothing but a bowl of light and breath, a place set aside for thought. Elias slid a pencil behind his ear, and without grand gestures or a judgmental clearing of the throat, removed a slim volume from the shelf by the reference desk, Blackstone essays and a battered primer of pleadings. He tucked one under his ledger, left the other where the newcomer's shadow fell, and watched. The fact of his kindness announced itself as small and precise. It was not a charity note attached in bold. It was a dog-eared law primer with a reservist's bookmark lodged at Chapter 1. When the man reached for the book, his fingers brushed Elias's, and there was the briefest exchange. No names, no histories, only the shared ancient recognition of hands that have held paper. The newcomer took the book, as if he had been given permission to keep thinking. The library was nominally a place for all, but the town had rules, and rules are windmills for those who have been listed in legal papers. Landlords refused, foremen hesitated, employers tutted. A man with a record could be told politely that there were no suitable positions for him. He could be offered work at the edge of things, sweeping stables, stacking hay, and never be trusted with a key. Books, Elias decided, were different. They did not carry the weight of gossip, only the quiet manner of ideas that might, if someone bothered to examine them, broaden a field of options no one thought to offer. He left the library the night the man came in, and the quiet grew around his small gesture. The primer sat on the newcomer's lap as he read by the gaslight on the bench outside, and the pages were soft with the warmth of his thumb. He read definitions out loud once, and then stopped, embarrassed by the motion of his own voice. He read on into the dark until the street lamps blinked, and he clutched the book like a small, newly acquired map. The newcomer, whose name was Samuel Reed, had served his time for a mistake he never argued about in public. He had been 19 the first time the law took his years, and 27 when he left the gate with a number stitched into the past like a scar. In prison he learned to do hard things. Mend a roof, boil a kitchen pot without losing the broth. Read the night for the quiet ways a man could keep a place in his head, untouched by routine blame. He learned, too, the long arithmetic of regret. It was not a story of glamour or of grand criminals. It was the ordinary kind of failing that those with little choice fall into, One bad bet to quiet a child's hunger, a moment of bad company at the wrong time. The papers had called him an ex-convict, and the town circled him like crows at a feeder. He had come to this small county seat because it was far enough that no one would instantly put his two names together, and because in the map of possibilities he had kept in his head, words were the only currency he could imagine being accepted. Elias watched him for months before giving another note. He had the librarian's indisputable ways of measuring people, who returned books on time, who cared for the spine as if a book were a patient. Samuel returned books with dog-eared corners and a careful pencil underlining, habits that are less the mark of a criminal and more the mark of someone who intends to stay. Elias made his offers in silence. He marked a book as reserved under Samuel's name when the ledger asked for a patron ID, created a library card in a hand precise enough to be mistaken for machine script. He slipped him the smallest of tools, an index card with a single sentence inside a law volume, an instruction rather than counsel. Start with the foundation, learn the language of the rules. There are kindnesses that announce themselves with trumpets, and there are kindnesses that fit in envelopes. Elias's method was the latter. He understood anonymity as respect for dignity. He believed that making someone feel indebted for their very chance at dignity could crush them. So he learned to give as a librarian gives, with fingers that never left the folio and a refusal to be seen. The town, meanwhile, listened and judged. The barber kept his chair away. The grocer offered credit in small increments. Samuel knew he owed the world an account. He had run numbers in his head until his bones were tired of arithmetic. But what he did not know was the shape of the map he would need to chart a future. He could read part of a case in the primer, the idea that words like tort and contract were not incantations but precise tools. And for the first time since he was a boy, he felt the small, steady lift of possibility. Elias arranged, quietly, and with the kind of patience that comes from years of shelving history, things that would be useful, and yet undetectable as assistance. He coaxed a retired clerk from the county office to lead an evening session on civil procedure. He used his unpaid stipend from the county to buy a second-hand volume on pleadings and left it on the return shelf where Samuel would find it. He began to interleave his guidance with the town's rhythms. A book left in the inn's parlor, a note slipped into the margin of a public ledger pointing to a page of precedent. He never spoke of the river of cause that would carry Sam along. He only plotted the stones the man could step on. "You can't learn law from a bookshelf alone," Elias said once, in the comfortable hush of the late stacks, when Samuel had lingered long after the lanterns had dimmed. "You learn how to speak it. You learn to listen." Samuel had laughed in a small, embarrassed way. "I don't even know which end of a case to look at," he admitted. He said it like a confession, and Elias met it like a catalog entry. "You start with the problem, then the rule that fits it," Elias replied. "We call it Iraq in the textbooks: issue, rule, application, conclusion. It's a neat way to climb a mountain. You find the issue, the law points the slope. You make your choice in the climb." The phrase made Samuel smile. It made the study of law sound less like a fortress and more like a trail map. To learn, he began to practice speaking aloud in the library's back room where the air smelled of paste and the hours left a faint residue of dust. He formed the silences between words as if they were sentences in their own right. Once, after a lecture at the inn organized by the retired clerk, Mr. Baxter, a man who had a fondness for ink stains on his cuffs, Samuel rose during the question hour and delivered a shaky, earnest recitation of a standard pleading he had practiced. His voice trembled, but the logic was sound. People in the room murmured, some in derision, some with the small surprise that stigma sometimes provokes when it sees competence. A young teacher in town, who had come out of sympathy and stayed for curiosity, offered to let him practice with her pupils on rhetorical exercises. The children were merciless in the best way, They asked simple, clean questions and never stopped at someone's past. Progress came, as it often does, in increments disguised as failure. Samuel failed to get a job at the mill because the foreman feared the gossip. He delivered a draft motion to the county clerk, only to have it returned with a note that records must be registered by a licensed attorney. He had no license. The old law primer reminded him that in some counties a man could be admitted to the bar by examination or by study under a practicing lawyer. In other counties, the process was at the mercy of judges' decisions and custom. The rules were as variable as river currents. When Samuel asked Elias how one became a lawyer without a patron, Elias's face pressed a paler groove into the lamplight. He explained, not as tutoring, but as fact, how in corners of the frontier and in small towns the path to a bar was often negotiated in 3 ways: apprenticeship to a local lawyer, a formal examination if the judge consented, or a certificate from the county clerk observing that a man had been of good moral character and competent to argue his case. "Character matters," Elias said. "But so does competence. Neither alone is enough." This last sentence sat on Samuel's tongue like a challenge. Character mattered in a town that had already decided a verdict. Competence was the only thing he could build that might shift a mind. He began to work as if competence were a profession of faith. He wrote briefs in the back of a ledger, hand-scribed by Elias's careful penmanship, and used a worn fountain pen to practice signatures he could imagine one day putting on motions. He memorized the way legal phrases were ordered, the little incantations of form that made a statement become admissible. Elias, for his part, kept the mentorship modest. He placed an anonymous card in the primer whenever he thought Samuel needed a prod. The card would say something like, "See how the court used the term reasonable here." Ask, what makes it reasonable? Apply that to the facts you know. It was not grand counsel. It was a habit-forming appliance. He taught Samuel to be precise, to consign emotion to the appendix of argument, and to put evidence at the center. The town provided companions and obstacles in equal measure. Mrs. Dean, who ran the boarding house on 2nd Street, kept a separate kettle for Samuel and warmed his soup because she had once lost a son to disease and could not look at a hungry man without pity. The blacksmith took the measure of him and offered to teach him to shoe horses. Hard, honest work that kept his hands busy and his mind disciplined. There were neighbors who spat at him in the street and others who slid coins into his palm when they thought his steps too slow. It was during a March thaw that the first real test arrived. Tests in life often come disguised as other people's crises. In this case, it was Mrs. Larkin, a widow whose small parcel of land near the mill had been seized when her husband defaulted on a debt. The local merchant, Mr. Connolly, had a ledger and a temper. He claimed Mrs. Larkin had signed a note she didn't understand, and, after the sheriff posted a notice, creditors began to circle her property. She came to the library with an envelope of papers, trembling, and she found Samuel there, leafing through a treatise on property rights. "You came to town too late to hold on to things," she told him, and the words hurt like a small stone thrown at a window. Samuel folded his hands and listened. He could have said nothing. He had no license, no standing, no reputation, but the primer in his satchel whispered a dozen useful procedures to him. He took her papers, read the names and dates carefully, and offered a plan that was confident in its modesty. Gather witnesses to the husband's financial standing, check the ledger entries in town, find any defects in the note's signature, and petition the justices for an injunction on a technicality long enough to buy time for a fuller defense. Mrs. Larkin did not look at him with pity. She looked at him with the raw, human gratitude reserved for those who offer a concrete path out of despair. In asking for help, she also put him in danger. Assisting the widow would force Samuel into the public square, and in the public square his past could be brandished as a reason for dismissal. "Why you?" A neighbor hissed when the townsfolk heard the rumor. "He's got a record." The merchant, Connolly, turned the phrase into a taunt at the grocers and the butchers, pointing to a ledger where the widow's name sat under an overdue column. Samuel's choice was simple and costly. He could step back and let someone licensed argue the point. But those licensed lawyers were busy in larger towns and less inclined to take cases that offered little prospect of fee. He could be practical and let the land go. Or he could try, as a layman, to file the petition himself, arguing for the right to be heard and for the procedural flaw he suspected in the merchant's claim. Elias, who had observed the small law of mercy as a librarian's duty, pushed him toward the harder, quieter path. "Your work will be to make them look," Elias said when Samuel expressed doubt. "If a judge sees the facts up close, you might win. Judges are not immune to evidence." "But I'm an ex-convict," Samuel said. The words were not bravado. They were a careful accounting of the weights he already carried. "They'll laugh. They'll look at you and at the papers," Elias said, "and they will note which of those carries more weight." They prepared. Samuel collected signatures from neighbors who had once seen Mrs. Larkin's husband pay. He walked the Mills lot and found a man who would swear that the note had been taken in a time of confusion. Samuel transcribed the entries in the merchant's ledger and compared dates. He learned how to frame a question so it would not be swept aside as irrelevant. He learned how to draft a petition that forced the clerk to put the case on a docket and to schedule a hearing. Each small technicality was a step up a porch that had not been built for him. Naturally, the town watched. Mr. Connolly, whose life was a ledger of grievances, made a show of contesting the entry's authenticity. The sheriff, who took his cues from long-standing reputations, delivered a polite warning that anyone bringing legal action should expect scrutiny. The minister, who had known Samuel's family, took a cautious stand in the pulpit. "Forgiveness," he said, "does not mean recklessness." And yet, there were unexpected allies. The schoolteacher, Miss Adelaide, stood up at a social club and spoke of the students' respect for Samuel's discipline. Mr. Baxter, who had more ink on his cuffs than solicitude, offered to testify about the accuracy of Samuel's transcriptions. Mrs. Dean, who had warmed his soup, signed an affidavit about the Larkins' regular payments. The community's ordinary kindnesses began to stack as evidence of a different story. When Samuel filed the papers, it was a small ceremony of courage. He walked into the clerk's office with a satchel and a clerk's certification that Mr. Baxter had prepared, then paused, as if at the lip of an ocean. The clerk, a woman named Hester, examined the hand-scribed petition and frowned. "You're not an attorney," she said, with the weary wear of one who has seen rules used like clubs. "These things are usually filed by counsel." "I'm not asking for courtesy," Samuel said. "I'm asking for a docket date." "There are rules," Hester replied. "If a judge sees fit, one might be allowed to speak for a neighbor, but it is unusual." Her pen tapped a rhythm like small hail. "You'll need more than heart to change the docket." Samuel placed his hand on the petition as if it were a relic. "I have facts," he said. "I have witnesses." He carried the papers away with the steady, unfinished gait of someone who had learned how to wait out storms. It was then, outside the clerk's window, where the afternoon light made everything look like a blown-out photograph, that a man he had known in passing tapped his shoulder. "You got guts, Sam," the man said. He was the kind of person people did not notice until they wanted you to. Thin, with a jaw like a well-used hammer. Mr. Grafton, who ran the livery. "Don't let them make you small." "Thank you," Sam said, and for the first time in many seasons, he felt his chest loosen. That night, at the library, Elias left an index card in the primer where Samuel would find it. The card was small and precise. "Remember to put the burden of proof where it belongs." The library clock ticked with a soft patience. Samuel took the card like a passport. Word spread, as it does in towns where the hours have to be filled with gossip. The hearing was set for a cold Tuesday in March, and by then the rumour had taken on a kind of narrative life. The ex-convict was going to try to stop a merchant from seizing a widow's land. People took sides as performatively as they steamed coffee. Some lent their sympathies like blankets, others tightened their lips against what they saw as the possibility of disorder, and there was the question of the bar. If Samuel intended to mount a credible case in front of a court, some would require him to show formal standing. He had no degree, no license, only learning and a ledger of neighbours who would testify. The law in their county allowed a judge discretion to permit laymen to speak on their own behalf or on another's if invited. It did not require universal uniformity. It was, in other words, plausible that a carefully constructed petition could get a hearing. It was also plausible that the town's prejudice would be deployed to shut him out. Confidence must be earned as a thing of muscle, not of whim. Samuel learned to anticipate a judge's question and to answer with documentary precision. He practiced tone, how not to speak as a man begging punishment, but as a man presenting facts. In the library's back room, he rehearsed with Mr. Baxter and with children who, merciless in their curiosity, asked him the blunt questions any tribunal might. "You must lose your temper in court," one child demanded. "It makes people think you're a man." "No," Samuel said. "You must keep it, because anger can make you foolish." "That's not fair," the child said, and Samuel laughed. The laugh was the only unbroken thing in a day that ended with his fingers stained with ink. Elias watched these small, teachable offences with a pride he did not name. He was not the sort to take credit. Sometimes he thought of the way a librarian is like a gardener who waters in silence and lets others harvest. Sometimes he imagined a plaque, years hence, that would have his gift understated and unnamed. Not every test was to be met by argument. There were nights when Samuel walked the river and felt that his old sins had been tattooed onto the stars. There were nights when he was tempted by those who traded in the town's underside. Old friends from before his sentence drifted in on winds of memory and offered him lapses back into what was safer to them. Thefts that seemed easy, cons that promised fast wages. These offers were like mirrors held up at an angle. If he turned his head at them, they reflected only the worst parts. If he refused, he felt a loneliness, like an empty bench in winter. He refused. He went back to his books and his ledger, and to the long, slow work of being someone who could be believed. Elias's notes helped, little appointments scribbled in the margins of the primer. Practice cross-examination. Ask what the merchant will admit on the stand. Each note was a rung on the ladder he climbed. The night before the hearing, Samuel found in his satchel an unexpected thing. A stamped library card with a hand he recognized as Elias's, only this time it bore a different name in the clerk's hand. It was the neat anonymity Elias preferred, a public record that offered no public recognition. Samuel ran his thumb across the embossed letters, and for a moment the small piece of paper was more valuable to him than a purse of coin. He slept badly. He dreamed of ledger pages that turned themselves into doors, of a judge who carved lines in the air with a gavel to say who could speak and who could not. When morning broke, it came thin and pale as linen. The courthouse, a squat building of stone and weathered wood, sat like a small fortress on a hill. People gathered, some on one side, some on the other, many with no more than curiosity. They formed whispers the way steam forms over a kettle, and Sam's name rippled through like a small stone thrown into a larger pond. Elias did not attend the hearing. He never attended unless he had to. His method of mentoring had always been to step back when the stage got bright. He believed a man must be allowed to risk, and he preferred the quiet of the stacks to the cheer or derision of crowds. Instead, he left another card in the primer. Speak plainly. Let the facts stand like old stones. trust in preparation. At the courthouse steps, Samuel met Mr. Baxter and Mrs. Dean and Miss Adelaide, each carrying an affidavit and an expression that was part anxiety, part resolve. In his satchel, he kept the law primer whose edges were fanning out from too much use. He smoothed the cover and felt under his palm the little slip of card Elias had placed there months ago. Start with the foundation. He began to breathe as one does before a long race, counting seconds like paces. Inside the courtroom, the wood smelled of polish and old arguments. A clerk called the docket in a voice that seemed to lower all hearts. The merchant, Connolly, sat smug and precise, his ledger open like a book of incantations. He had assembled witnesses and notes. Samuel placed his petition on the bench and looked up as the judge came in. A woman with a deliberate face and hair pulled back as if law was, always, meant to be a tidy thing. She had a reputation for fairness, but fairness walks a tidy line in a small town. Community sentiment tends to hover where the judges breathe. The hearing began with the ordinary business of names and citation. Then it became the act that would, in the small ledger of local history, define pages. Samuel spoke first as an ordinary man, and then, with the practice that had been hewn upon him, as someone who had learned the law's grammar. He introduced the facts. He called witnesses. A neighbor who had seen a ledger entry crossed out, Mrs. Dean with her kettle evidence, Mr. Baxter with his clerk's certification. Connolly's attorney, an urbane man who spoke for effect, tried to make Samuel's past into a reason to dismiss the evidence. Why should we trust testimony arranged by a man with a record? Connolly's counsel asked, and the room hummed with the long-understood expectation that reputation is a currency as heavy as coins. Samuel answered with the simplicity of someone who had practiced retorts in the lamplight. He dropped each fact like a pebble until the edifice Connolly had raised began to show hairline fractures. He asked questions so steady that even those predisposed to scorn began to see evidence in the motion of his speech. He called attention to dates, to the merchant's irregularities, to a signature that did not match the widow's usual mark. The judge asked a few sharp questions, and the merchant's counsel offered the kind of rhetoric employed when one wanted to obscure specifics with generalities. The audience leaned in. It was in the middle of his cross-examination that Samuel felt, briefly, a pressure at his back, as if the town were holding its breath. He could have crumpled then, tempered by years of sentences, but he kept the shape of his voice narrow and strong. He used the kind of phrasing Elias had taught him: issue, rule, application. He drew a line from the ledger's irregularities to the merchant's procedural steps, and the line was hard to deny. Outside the courthouse windows, a wind lifted the flags. Inside, the judge took a pause, and then ruled that the affidavits merited a further hearing. It was a provisional victory, the kind of small success that can topple assumptions if followed by more careful labor. The sheriff relaxed by a fraction of a breath he hadn't known he'd been holding. The merchant looked unsettled. The crowd, which had come to see either a spectacle or a spectacle of disgrace, dispersed in fragments. Some quietly pleased, others annoyed. Samuel walked out as if the world were the same but slightly rearranged. He had not won final vindication. He had earned permission to continue. It was the legal equivalent of being given a second chance at a paraphrase. You may proceed, but the proof is still to come. As he stepped down the courthouse steps, someone called his name. He turned and saw a boy, one of those children who had once drilled him in rhetorical exercises, waving a nearly drawn cartoon of a judge and a merchant, and who then, embarrassed, ducked his head and ran. Samuel laughed with a sound that was almost relief and almost astonishment. It was then, back at the library, that a small mystery presented itself. A municipal clerk came in to return a set of county records and left, by mistake or design, a folded envelope in Volume 3 of the record series. Samuel found it as he shelved, a plain thing of cream paper with no seal. He unfolded it and found inside a note in a careful, measured hand. Continue. There was no signature, only the faint impression of a pressed thumb at the corner where someone had held the page. He looked up at Elias, who was at the reference desk pretending to arrange new catalogue slips. "You've been very kind," Samuel said, because kindness must be named, especially when one suspects it is deliberate. Elias smiled the librarian's smile, small, private, and did not answer directly. "Books are for use," he said, a line of principle more than confession. "And men are for work." Samuel considered pressing, but he had learned the value of small mysteries. If this man wished to remain anonymous, it was not his place to unveil him. Besides, there was work to be done. The note had done what notes do. It had pushed him onward. The card in the primer had always been his to convert to action. There was a new pressure now, quieter and not entirely personal. Word had reached the county seat that the case had attracted attention beyond their borders. An attorney from the neighboring district had written a sharp editorial about frontier mercantilism and the perils of lax creditors, and the county's legal elite began to monitor the docket as if the center of gravity had shifted. Samuel understood, because Elias had taken care to make sure he did, that higher scrutiny could cut both ways. It could bring a better, sharper review, or it could summon forces that would make his small courage look like folly. The next morning, he found another card tucked into the binder he kept of notes. A single line in the margin. "Prepare for character scrutiny. Bring witnesses who have seen your reform." It was the kind of advice one gives a man about to climb a ridge in a storm. Samuel felt the tremor of it in his stomach. He gathered his witnesses and his notes, and rehearsed his words until the syllables were no longer strangers. He did not yet know that the merchant had decided to turn personal. Connolly, stung by the public embarrassment of the previous hearing, had begun, in whispers, to strategize how to discredit Samuel's character as a way to discredit his argument. It was a reasonable tactic in the world they inhabited. If the man could be made to appear unreliable, his testimony could be nullified. Connolly's counsel dug into newspapers and past records. They found a small handful of in the world's memory and began to build the scaffolding of a narrative that would say more about fear of disorder than about justice. Samuel sat in the library late the night before the next hearing and folded his palm around the fountain pen Elias had given him months before. The nib had a small chip, worn down by practice, and he ran the tip across a scrap and wrote the first draft of what would be his statement. He wrote, not in the language of apology, but in the language of facts. Dates, names, signatures, and the clean, steady cadence of someone who had rehearsed the law as if it were a hymn. He felt the tremor of the town's attention like static. Elias watched him without a flicker. He moved about the stacks, reshelving, making the library seem as if it had always been organized by calm hands. Occasionally he would leave another small instruction tucked between pages, a reminder to check the merchant's ledger against the county's tax rolls, an observation about the comfortable habit attorneys had of obscuring the obvious with jargon. These were not grand theses. They were the kind of counsel that can unseam the limbs of a carefully built argument when applied at the right moment. As the sun slid away that evening and the lamps came on, casting pools of light like islands, Samuel packed his satchel. He put the law primer to the top, the card Elias had left folded in its spine, the fountain pen capped and the affidavits carefully wrapped in parchment. He paused at the doorway and felt the small, sweet weight of people's hopes. Mrs. Larkin's face, Mr. Baxter's ink-stained cuffs, Miss Adelaide's pupils who would whisper about his courage for weeks. He walked back to the courthouse with the deliberate tread of a man who must make his life count for something beyond himself. The town was quieter now. The moon hung like a thin coin. He felt, as he climbed the steps, the absence of a name he had come to rely on, Elias's public face. But he carried the secret cards like proof that someone had stood behind him in a manner the town could not yet see. The night before the hearing closed, Samuel received one more small thing. An envelope with a stamped library card, and beneath it, a page with a single sentence written in a hand that had been taught under a steady light. Do not be surprised if they try to make you small. Stand large by the truth. There is power in steadiness. He did not sleep. The next morning, as the town gathered and the courthouse's doors opened like the mouth of a particularly consequential animal, Samuel paused on the threshold. He did not yet know how far the town would let him ascend, or how mercilessly it would push back. He carried his primer, his pen, his witnesses, and the weight of an anonymous librarian's belief. Inside, the docket would call his name. Outside, the town would watch. The air felt suddenly like the space before a season turns. A suspended, breathless place where a single voice could tilt the balance between ruin and repair. He stepped into the courtroom and felt the room take him like an auditor takes a breath. The wood was warm beneath the judge's bench. The light through the high windows cast long, honest bars across the faces gathered to watch a small town decide a small thing that would come to mean much. Samuel carried his papers like a shield, and beneath them, the primer, whose pages had been softened by more hands than his own. There was a hush that was not reverence so much as the town's habit of listening when something unusual happened to ordinary life. For a moment, the room was simply the room. A calendar pinned with last year's holidays, a portrait of a long-dead benefactor, the clerk's inkpots arranged like a little army. Then the clerk called the cause, and the business of things, dry, public, inevitable, resumed. Connolly sat with a posture that suggested his ledger was part of himself. His attorney, a man with a bow tie and a taste for theatrical pauses, swept his eyes over Samuel, as one might sweep dust off a table to find the coin hidden beneath it. The judge, who had the look of someone who had learned how to hold balance between law and town, tilted her head and waited for the opening. Samuel spoke as he had practiced, clear, slow, the cadence of someone who believed that the law must be said plainly, so that its meaning could be found. He framed the issue, whether Mrs. Larkin's note had been validly executed, whether the merchant's claim met the requirements for seizure, and he pointed to the concrete facts, signatures, ledger entries, dates that did not line up. He invited the court to look at the record as if it were a map and not a pile of accusations. Connolly's counsel rose with the sort of well-rehearsed scorn that comes from a life of winning in rooms where power counts for more than precision. He attempted, in his opening, to make Samuel's role appear theatrical, if not improper. A layman meddling in affairs that rightfully belonged to licensed counsel. The words record and character curved like a blade towards Samuel's past. When personal history was invoked, Samuel felt, as he always had felt when a man's life was pulled into the light, the sense that the world was about to permit itself an easy verdict. But this time he had more than a raw face to present. He had affidavits, ledger comparisons, and the steady testimony of neighbors who were not bribed into loyalty. He had practice. He had procedure. He had, more difficult to quantify, a public that had started to look at him differently. The attorney for Connolly pushed character as a weapon. He held up a clipping from an old paper like a talisman and suggested that the past should shape judgment of the present. We ask why the court should accept the testimony of a man whose life has been marked by the law in a way that, shall we say, complicates his credibility, he said with an arched eyebrow. And the town, which takes certain moral weight seriously, tracked his cue. Samuel did not answer with invective. He answered with evidence. He called Mr. Baxter, ink-stained, slow-tongued, and precise, to the stand, and Baxter stepped forward, not grandly, but with the tired dignity of someone who knew how to read a ledger. Baxter testified about the ledger entries he had transcribed from the merchant's books and about the irregularities he had found, payments that had been recorded and then crossed out at later dates, the merchant's hand inconsistently tracing the widow's mark in a way that betrayed haste, or worse, and a day on which the merchant had recorded a transaction twice. Connolly's counsel attempted to poke holes in Baxter's testimony. What were his motives? How certain could he be? But Baxter, with a clumsy sort of moral uprightness, answered that he bore no affection for trouble, but no appetite for deceit either. "A man with a ledger has to keep it honest," he said. "Otherwise it is no ledger at all." Witness after witness brought small things. Mrs. Dean's kettle was evidence of routine. A neighbour's reference to a past payment brought in a page from an old tax roll. Miss Adelaide, with the bluntness of a teacher who knows children watch grown people more honestly than grown people watch each other, spoke to Samuel's discipline. How she had watched him practice rhetoric with the very pupils who would later cheer his name. These were not flowery testimonials. They were narrow, factual glimpses that together formed a picture of commitment. Connolly's counsel grew sharper, desperate to find a flaw he could tattoo across Samuel's credit. He tried to suggest that witnesses were biased, that the town's small mercies were bought by sentiment, that the affidavits were arranged by someone with an agenda. It was then that the merchant reached deeper, to that part of the town's memory where labels are durable. He moved to make Samuel's past the fulcrum on which all doubt would be levered. He asked for the court to consider Samuel's conviction as a reason for his testimony to be discounted. In doing so, he invited, perhaps unwittingly, a recalibration of how this small civic sphere measured reformation. Samuel expected this. He had rehearsed answers that would not come off as defensive, but as unvarnished information. He did not deny his past. He described it, briefly, plainly, allowing the court to consider that admission in light of the other facts. There was an odd solidity in preventing that moment from being fodder for dramatics. When a man refuses to be shamed into silence, the public sometimes has no choice but to reckon with what they have been assuming. "Your Honor," Samuel said when given the floor, "my life is a matter of record. I don't ask to have the past erased. I ask only that the court consider what the papers of this town now show. The ledger, the signatures, the witnesses. Whether I paid for my mistakes does not prove whether Mrs. Larkin did or did not sign what Mr. Connolly claims." He laid out the chain of factual discrepancies and, rather than pleading character, invited scrutiny of paper. The judge listened. She did not sweat the theatrical. She asked narrow, precise questions about dates, about county record-keeping, about a clerk's habit of notation. Those questions allowed the small facts, Baxter's comparison, Mrs. Dean's bill-paying testimony, the copy of an older tax roll, to accumulate like blocks until the edge of the merchant's story showed a crack. Connolly's counsel tried to shore that wall with rhetoric, but where words fail, the record often does not. The judge, after a long, careful pause that made many bodies in the courtroom straighten as if pulled by strings, ruled that there was sufficient cause to halt the seizure pending a fuller hearing, a temporary injunction. It was not final victory. It was something harder to obtain in a town with a memory, the right to be heard and to produce greater proof. Outside the courthouse, gossip split and rejoined like river currents. Some called it a scandal, some a minor correction in civil procedure. For Samuel, it was a breathing space. For Mrs. Larkin, it was the first night she slept without the fear that a man with a harrow of creditors would walk in and lift her hearth. People shook his hand with the cautious gratitude that townsfolk reserve for those who meet small crises with competence rather than theatrics. In the days that followed, the tone of the town shifted in increments. Not everyone forgave anything. Some merely recognized that the legal apparatus could work if given evidence. There were, of course, those who remained vehement. Connolly's defenders pressed on, and he filed an appeal and some letters to the paper with phrases like danger of encouraging lawlessness that made the town's more cautious citizens murmur. But the base facts had been set into the public record, and that made gossip less decisive. Amid the small victories and public friction, Samuel kept receiving the librarian's subtle counsel. Cards appeared in the primer with single lines, reminders to cross-reference a date, suggestions to seek a particular deed in the county papers. Once, he found a slip tucked into the corner of an index with a sentence he would remember for years. Make the mechanism obvious, and the motive disappears. The notes never named Elias, but their presence was as real as a hand at the shoulder. And yet the town had its own law of proportionality. When a man's life grows public, scrutiny comes in gears. Connolly was not content to lose a single seizure. He pursued reputation as strategy. He hired an investigator to look into Samuel's life, scavenging old files for anything that could be turned into doubt. They pored over the margins of Samuel's past in search of some failing that could be recast as evidence of present unreliability. It was, cruelly, a common tactic. Make the worthy seem weaker by making past errors live loudly. Samuel felt the old pull of shame and the new strain of endurance. He worked through the days like a man on a ship who must keep the sails tended when a storm is named, and so he practiced and he prepared, and he made sure his facts could be lined up against anything thrown his way. The next hearing required more than a ledger comparison. Connolly's counsel brought forward a witness who suggested that the widow's signature could not be verified with certainty. The merchant's man argued the case as if certainty were a measure of character, not of writing. Samuel answered with a small ceremonial display of method. He showed a sequence of documents that connected the widow's mark through her usual routine. Bills paid at particular times, a neighbor's recall of the widow's hand on a grocery list, a pattern that in itself suggested authenticity. In short order, the judge allowed a handwriting comparison, and with the formalities of procedure came a different kind of observation. When processes are honored, perceptions must shift. During this phase, a small, almost bureaucratic drama unfolded that would come to matter more than the town expected. The municipal clerk, or rather, the deputy clerk, a woman named Hester who had quietly observed Samuel's steadiness, was tasked with searching older county records to find any prior instrument bearing the widow's mark. In those bound volumes, she found a marginal notation that had been overlooked. It was not spectacular on its face, a penciled cross beside a register entry from a decade earlier. But it did confirm a pattern. The widow had consistently used a mark that matched the disputed signature. What made that discovery uncommon was not the penciled cross, but the margin of the page upon which someone had once left an index card. The card, yellowed and faint, held nothing grand, only a reference to a prior encumbrance that had been cleared. But the way it had been stored, casually tucked into the book's seam, suggested a clerk who had once tried to make the paper trail clear. Hester, who had a practical mind and a private fondness for tidy records, testified to the regularity she had found. To an ordinary observer it was minute. To the court it was confirmation that the widow's mark had been part of the record for years. Behind this minor evidentiary turn lay Elias's quiet hands. He had not fabricated documents. He had known the county's records and had left notations and cross-references in the library's copies and in public volumes where a man who sought the truth might find them. His role was to make access possible, to point to where a fact could be checked. Those who worked in the bureaucracy of the town, Hester, Mr. Baxter, had the habit of returning to their ledgers and retrieving the small proofs that kept civic transactions honest. Elias's method was the slow, patient clearing of undergrowth so that a path could be seen. Connolly, frustrated and increasingly cornered in the public eye, grew more vicious in small ways. He spread rumors that Samuel's success was orchestrated by a manipulative outsider. He tried to file counterclaims that were flimsy and expensive to fight. But each motion required a notice, an affidavit, a paper trail. Samuel, who had once been on the receiving end of the law's patience and its harshness, now used the same tools to defend neighbors. There was something ironic in seeing the ledger trade hands. It was not long before a regional attorney arrived in town, Mr. Whitmore, a circuit lawyer who had watched the hearings from a distance and been impressed not only by Samuel's arguments, but by the way he marshaled witnesses. Whitmore, who had spent his career traveling from county seat to county seat, had the kind of judgment formed by seeing systems work well and fail badly. After the injunction, he sought out Samuel through the library, an entrance that suggested he was looking not for combat, but for craft. "You have a mind that can talk to the law," Whitmore said when they met under the stacks, as if the dust between them made for a kind of mutual understanding. "There's a way for you to do this work properly, by reading under someone who has practiced and by meeting the standard of admission. If you would consider it, I could recommend you to a bar panel. The work you have done shows capacity." Samuel's throat worked at the offer. To be officially recognized, admitted to practice, would change not merely his title, but his standing in ways that could protect him and grant him tools to help others. But it would also mean more exposure, more scrutiny. "I'm not sure the town is ready," he said. "I'm not sure I am." "Readiness is a funny thing," Whitmore replied. "Often the work itself demands the readiness. You'll have to study things you already know in the abstract. Pleadings, civil forms, the art of examination. But I'll give you a letter to the court, and if the judge sees fit, you may be examined here." It was a plausible, historically faithful route. Judges in many small jurisdictions did admit capable men to practice when they could demonstrate proficiency. Whitmore offered supervision. Samuel accepted. The arrangement was modest, no grand tutelage, but a path. He would continue to read, he would apprentice in the habits of law, he would be examined by the court, and if found competent, allowed to take the title of attorney. Elias watched this development with the careful distance of a man who had never sought a byline. He continued to leave notes, to curate volumes in the library that would prove useful to someone reading law by necessity rather than by university. He arranged a small shelf with pleadings and practical forms and marked the spines in a code known only to him, index cards tucked into pages where a man could find precedents. He did not announce these gifts. He arranged them like a gardener who leaves seedlings in the soil, expecting no medal. As Samuel readier himself for the admission process, Connolly did not relent. He appealed the injunction, and the two sides moved toward a more formal hearing that would test not only the widow's claim, but the town's willingness to see someone with a record argue for justice. The hearing became a larger affair. The regional legal community paid attention. The local paper ran editorials that skewered notions of mercy or applauded the power of the law to provide a fair day in court. The stakes had widened. This was no longer only about a parcel of land. It was about whether a town would allow a man to repair his civic standing through competence and service. On the morning of the decisive hearing, the courthouse was fuller than it had ever been for such a local dispute. Men who had once looked askance stood with a different expression. Mrs. Larkin's neighbors cradled their petitions like talismans. Whitmore sat in the back, not to take the stage but to observe, a ready mentor. Samuel walked in with the simple confidence that comes from preparation. He had studied a pattern until he could see the law like a constellation, issue and rule, evidence arranged as the stars. Connolly's counsel, irritated and a little pale now that his theatrics had not done the work he expected, brought forward a new line. He sought to discredit the documentary pattern by suggesting that copies could be manipulated. If you make a ledger look like it says one thing, he argued, you could make a widow appear to have paid when she had not. It was a plausible if cynical tactic. Samuel replied the way a man who has prepared replies, by building a chain of custody for each contested document. He showed the court how Hester had found the penciled margin entries, how Baxter's transcription matched the book in the merchant's hand, but differed in small ways that suggested the merchant's later alterations, how Mrs. Dean's ordinary recollections of payments fit the dates where a rightful signature appeared. He invited the court to consider the pattern, not the single item. The pattern, he argued, simply made sense. The turning moment of the day came not from a flamboyant turn, but from a small human gesture. A visiting attorney in the third row, an older man who had traveled as a circuit judge in earlier years, leaned forward and addressed the bench, not as part of the argument, but as a witness to procedure. He spoke of the habits he had seen in courts, how merchants sometimes adjust ledgers to fit convenience, how witnesses are often more reliable than we assume, and how a court's role is to weigh process. His testimony was not decisive on the law. It provided context that made the judge more willing to probe the documents with a clear eye, rather than with the weight of town law. After a measured consideration, the judge ruled for a reversal of the seizure, at least for now, and ordered a full accounting to be presented in the next term. It was not a grand proclamation of Samuel's righteousness. It was a technical, accurate, and crucially, public correction. Mrs. Larkin would have her day. Connolly was forced back to the books. When the gavel fell, there was no cheering. Instead, people exhaled as if they had been holding their breath. It was the kind of aftermath where the town noticed, in a small way, that the world could be set straight by method and by witnesses who were willing to speak. The days after the hearing carried new currents. Samuel's situation began to look less precarious. The region's lawyers began to talk about his aptitude. Whitmore approached him about the possibility of formal examination. "If you want to be admitted," he said, "we will need to present you to the court for questioning and to vouch for your preparation. The judge will look at more than papers. She will want to see the mind behind them." Samuel decided to pursue the route. He studied under Whitmore in the afternoons, procedural forms, the art of examination, the history of precedent that had been most influential in their state. He wrote motions until his hand cramped, and read pleadings until he could see the architecture of argument. The library remained his anchor. Elias's marginal notes, "Start with the foundation, make the mechanism obvious," became mantras he repeated as he learned to translate theory into practice. There were setbacks. In a mock examination Whitmore staged, Samuel stumbled in a question about equity, pleading that required a subtle distinction. Whitmore did not scold. He suggested a reading and walked Samuel through a line of cases. "You're building a muscle," Whitmore said. "Muscles strain before they strengthen." Samuel's life was no fairy tale of uninterrupted success. There were nights when bills stacked, and when the mill offered him work that would require him to give up study. There were whispered hints from those who claimed he should be content with the chance he had won. There were also narrow and flattering offers, men who told him he was charismatic enough to make a reputation that would pay. He refused the fast certainties and continued the slow work that had initial cost but deeper yield. All the while, Elias's anonymity persisted as a motif and as a practice. He continued to leave the library prepared and arranged, a little envelope with a stamped library card here, an index card there, a second-hand volume of pleadings with margin notes. He would sometimes sit in a distant corner and read, or he would be seen tidying a shelf. People began to notice his presence in the background, and a few, those who had paid close attention, began to suspect he was more than a bare functionary. But Elias never claimed credit. He let his acts remain small, as if to prove that charity need not be announced to justify itself. The day of Samuel's formal examination before the court was simple and absurdly ordinary. He was asked a series of questions that mixed technicalities and a demonstration of applied judgment. The judge listened to his answers, occasionally interjecting to test a point. Whitmore seated himself with a quiet attentiveness. The town turned out in numbers for reasons that mixed part curiosity and part civic pride. Samuel felt the weight of expectation, but also the reciprocal fact that any man's competence could lift a community. When the court announced its decision, After a line of questions and a brief private conference, the judge admitted Samuel to practice. She did so not with a flourish, but with a note of judicial propriety. He had shown competency, character sufficient for his time, and a commitment to do the work with fairness. The clerk recorded the admittance with the same gravity accorded to county records. Samuel's name went down in ink. The town that had once used his name as a cauterizing label found itself meeting the fact of his admission with mixed feelings. Some stayed resentful, some felt vindicated for having stayed by him, and some quietly recalibrated their views. The ledger of human opinion is never balanced by a single fact, but facts have a way of nudging perception. When Samuel emerged from the courthouse and saw Elias at the far side of the square, their eyes met. For a moment, the space between them was the town's history, and the possibility nested within it. Samuel thought then, not in words so much as in a feeling, about names and reasons, and how invisible hands can make visible outcomes. He approached Elias, and in that approach a choice formed, to reveal a mentor by naming him, or to preserve the humility of anonymity that had been the librarian's preference. Samuel understood both choices. He had been shaped by the secret support, and part of him felt a need to name the origin of what he had become. But he also felt the quiet dignity of a man who had not wanted a ticker-tape parade, who had hidden counsel in index cards and second-hand books. What Samuel chose was a third kind of gratitude. In the public hall, where a modest reception was held, a modest assembly of those who had supported him, he spoke not of himself, but of the unseen work that had made the day possible. "There are hands that make paths without wanting to be trailed by praise," he said into the low hum of the room. "I have walked those paths. If there is a debt to be acknowledged, it is owed to someone who believed in access to knowledge, who placed things in reach of those who sought them quietly." He did not name Elias at first. He described him, a steady man who cared for books and for the truth, like a craftsman cares for his tools. Several in the room looked up, thinking perhaps of the librarian at the corner of Main, but no single person guessed all of it. Then Samuel, with the old fountain pen Elias had given him tucked into his shirt, took a book from the table and scribed, with a hand that had learned practice, a dedication. For those who believe in second chances. He then placed the book on the library's shelves, where a neat card would remain. Elias, who had come to the reception only because he had miscalculated his own desire to be present, smiled the brief, private smile that was his custom. He remained anonymous in the public sense. Nobody invented a plaque that day, but the small circle of those who had known and worked with them understood. The town had been given an opening. A man had been redeemed by his own labor and by the contributions of a quiet citizen. Time, as it does, moved the story forward in quieter ways. Samuel took a modest office above the tailor's shop. He advertised that he would accept small claims and pro bono cases for neighbors who could not afford representation. His practice was never rich, but it was the kind of work that changed lives in increments. A tenancy clarified here, a small will settled there, a dispute over a fence resolved without bitterness. In doing this work, he became a fixture not unlike Elias, a man people could turn to, who would speak plainly, and whom the law had formally recognized. Years passed, and the motifs that had signaled his beginning stayed at hand. The dog-eared primer, the first book Elias had left, remained on his shelf. The index card that said "Start with the Foundation" was folded and kept in a wallet. He kept the stamped library card Elias had once slipped into his satchel and used it to help others who came in like he had, people with pasts and fear and the hunger to learn. Sometimes he sat in the library's back room and taught small groups how to fill out a petition, how to assert their rights without rancor, and how to look at the law as something that could be shaped by evidence and honest pleading. Elias aged in the unobtrusive manner of those who spend their energy on the lives of books. His hair grew a little more silver. His cardigan gathered another patch. He walked a little more deliberately from desk to stack, but his eyes kept that same careful light. He continued to leave anonymous slips in the margin of a casebook to arrange a shelf so a desperate neighbor could find a statute. He subscribed to the conviction that the best mentorship is often invisible, a scaffolding that holds a building until the tenants move into the rooms. There came a year when Mrs. Larkin's case was fully resolved, with a final accounting that cleared her title and assigned the merchant the costs of his overreach. The ledger had been corrected. The public record was accurate. Connolly's stubbornness had not vanished. He continued to be a merchant with a sharp tongue. But the town's perception of what could be argued in fair measure had shifted. People noticed that the court could be a place that weighed facts rather than layered prejudices, and over time, that made it more likely others would seek representation rather than resign. As Samuel's career matured, he took on cases that were emblematic of the justice he hoped to encourage, defending those accused of petty crimes with an eye to rehabilitation, assisting families navigate minor disputes that, left unchecked, could grow bitter, counseling city committees on humane ordinances that balanced commerce with fairness. He became known for a steady hand more than for theatrical wins. His practice was a mosaic of small, honest acts. Meanwhile, the library on Main Street became more than a repository of volumes. Elias's small acts had changed the institution itself. He had, over decades, curated a corner of civic law. Starter primers, accessible texts, forms and precedents that any person could consult. He quietly arranged for an endowment that paid for evening classes, and he made sure that the old primer shelf had replacements and that a young clerk had money for ink. The library became the kind of civic instrument that makes second chances plausible by giving people access to knowledge rather than to rumor. There was a small ceremony some years later when the town placed a modest plaque in the library's law section. The plaque did not name Elias at first. It read simply, "To those who believe in second chances." People who knew the story, those who had been in the first hearing, and those who had sat in Samuel's early tutorials, recognized the gift and the person behind it. A few guessed at Elias. A few others had no idea. Elias, who had always been reticent about public recognition, approved of the gesture quietly. Samuel, standing in the crowd, felt gratitude that felt like a tide. It rose and touched everything. Not everyone asked for the secret to be revealed. The town had become accustomed to the fact that some people offer their best without press coverage. Yet there are moments when gratitude wants naming. At an anniversary of the library's endowment, Samuel rose and spoke to the assembled townspeople. He told the story in small measures, the way a man measures a life by the words he chooses to use. Not too many, not too few. He told them of the primer and the index cards, of the notes that had appeared. He told them of a man who taught a neighbor to look at a paper as if it were a landscape, and how that habit could change the way a community understands its own claims. Then, in the soft way memory makes possible, Samuel reached into his pocket and produced the fountain pen Elias had once given him. He signed a small book that would be placed on the library's shelf, and he said simply, "This is for the man who taught me to begin." At that moment, Elias stepped forward. He did not make a spectacle of himself. He came with the same understated gait with which he had shelved books for a lifetime. The crowd, which had expected maybe a remark and the end of the ceremony, sensed the significance in the quiet. A man choosing to be known after decades of anonymity. "Most of us do our work in the light," Elias said, his voice steady as the paper it had been his habit to handle. "But sometimes the use of a book is all the witness a man needs." He did not detail all his acts. He did not demand applause. He allowed the story to be a stone dropped into the pond of the town's life and to send out steady rings. People who had once stood stiffly when Samuel passed, now softened. A merchant who had once hesitated at the idea of a convicted man taking up the pen, stepped forward and offered a handshake. A woman who had once refused to sit next to Samuel on a bus crossed the room to place a small bouquet on the library desk. The town's gestures were imperfect and human, and in that imperfection lay the dignity of a slow, moral change rather than a triumphal overturn. In the years that followed, Samuel took on protégés of his own. He became a mentor in the way that men who have been mentored often become: patient, exact, and unwilling to hand out answers when another person must find the work for themselves. He sat in the library and taught small classes, his fingers smudged with ink, helping a young woman draft a pleading and advising a man on how to assert a tenant's rights. The cycle had come full. A librarian who had once given a primer had, in a chain of small acts, helped produce someone who would help others. There were visible consequences, too. Local bar admissions slowly opened to those who had once been easily excluded. The county clerk's office adopted a clearer process for lay petitions, and the library's law corner became a resource in morning and in evening for those who could not afford counsel. None of these changes solved every problem in the town. Such things are never wholly resolved by a single man or a single act. But the pattern of possibility had altered, and that alteration was the kind of thing that makes communities less likely to throw people away. Late in his life, Elias would sometimes sit near a window in the library and watch Samuel, now older, hair threaded with silver, a little more measured in his gait, teach a group of listeners how to draft a simple statement of claim. Elias's face, when he observed these scenes, held the contentment of a person who had seen a plan come to fruition without fanfare. He had not sought credit. His pleasure was in the evidence of use. The motifs that had marked Samuel's early work remained dear. The dog-eared primer that never quite lay flat, the index card with one sentence that could be used to prod a thought, the stamped library card that once opened doors. One evening, as autumn poured gold onto the street, Samuel found a new addition to the shelf where the primer lay. A small, unassuming card with a sentence written in a hand he recognized. It read, "Pass it on." He did. He began a tradition in the library. Each year he donated a book of practical law, forms, precedents, notes, for those who were preparing to take their first steps in advocacy. The book was stamped with the library's mark and with a little card that said, again, "For those who believe in second chances." People came to the table and obtained the book without fanfare. Sometimes they left a note of thanks. Sometimes they simply used it and returned it, dog-eared and full of margin notes. Elias died with the kind of quiet most of his acts had maintained. The library's notices announced only a small memorial service, and the town attended in numbers that suggested the depth of his influence. Neighbors, beneficiaries, a handful of those he had quietly helped without wanting notice. Samuel spoke at the modest memorial, not as the man who had been mentored to fame — there was no fame — but as someone who had been taught how to work. He read a passage from a book Elias had loved, a passage about steady hands that help others climb stairs. After Elias's death, some in the town argued for a lasting memorial, a plaque, a shelf name, something that would carry his name into the future. The arguments were tender and a little contentious. Some insisted that his anonymity had been part of his virtue. In the end, the community chose a compromise that honored both his humility and his effect. A modest shelf in the library was named the Harrow Collection, after his last name, and it carried a small card that read, "In honor of a quiet teacher who believed in giving knowledge to those who seek it." Beneath that card, one more in Samuel's hand was pinned, "To the man who taught me to begin." The final image that stayed with many who told the story later was simple and domestic. A worn legal book on a high shelf, its spine softened and its pages thumbed, with beneath it a small card, the same phrase that had moved through decades: "To those who believe in second chances." Children who grew up in that town saw the shelf and asked their parents about the man who had placed the books there. Parents answered with stories that were practiced in the way grown-up stories must be. Not too many details, but enough to teach a simple moral about generosity that did not ask for reward. Samuel, in his later years, came to be a quiet kind of hero in the town. He did not become famous beyond the county. He did not crave a statue. He ran his small practice. He took on clients who needed a counsel's steadiness rather than theatrics. And he taught young people how to read the law as a map rather than as a club. He would sometimes sit in the library's back room and run his hands over the old primer, feeling the roughness of paper the way some men feel a relic. He kept Elias's notes in a small box, and when asked about mentorship, he would say only that some people arrive wearing cloaks of ordinary jobs, but carrying the tools to change lives. The ripple effects of the librarian's discreet generosity continued long after both men had passed. The county clerk instituted a small program of public legal education. The library's endowment funded evening classes for years. Several individuals who had once stood at the margins of society found themselves able to navigate systems that once felt closed. None of this erased old wounds or made the town perfect, but the small cumulative changes produced a different climate, one in which a person's capacity for reform was seen as credible, and in which knowledge was the common currency that allowed second chances to be practiced rather than merely hoped for. In a photograph preserved in the town's historical room, a picture taken at the modest dedication of the Harrow collection, two men stand near a shelf. One is Samuel, a little older, a little more weary, but with an expression that suggests the satisfaction of a craftsman who has finished a difficult job well. The other is Elias, caught mid-smile, looking not at the camera, but at the shelf, as if he is checking the way the books line up. The caption beneath reads simply, "Quiet hands that changed a town." There are in life gestures that require no public record to be real. A hand that leaves a book, a card tucked into a folio, an evening class organized with a thrift of time. These are acts that change the arc of a life as surely as a courtroom ruling changes the legal fate of a parcel. The librarian, who preferred to work among spines, had no desire for a headline. He did, however, want the work he loved to be of use. He had seen, in small increments, what happens when knowledge is distributed, and when those who have fallen can be given the tools to rebuild. Samuel's last years were not dramatic. He walked the town with a measured step and took on cases that required clear reason rather than passion. He mentored a handful of young lawyers and taught evening classes in the library. At quiet moments he would run a finger along the dog-eared primer that had once sat in his lap on a cold night, and then, with a soft smile, he would add a card of his own into the margin. Pass it on. The story, retold by townspeople and a few who read it farther afield, often ends with that image. A worn legal book on a shelf, a card that asks anyone who picks it up to use what they learn to help. People asked once whether the librarian's anonymity had been his true gift. Others, more blunt, said that naming the man did not lessen his virtue. The truth is that his anonymity had been part of his style, but not his accomplishment. The accomplishment was the lives that altered because somebody decided to leave a primer in a stranger's lap. If one wanted to be didactic, one could draw a lesson that mentorship, humility, and a respect for knowledge are potent tools for change. But the story is not a sermon. It is an account of how a small set of practical acts, books shelved with intention, notes left in margins, access quietly provided, can change the tenor of a life and of a town. It is about how the apparatus of law, when paired with human decency, admits the possibility of repair. Years later, someone asked Samuel, in a quiet moment at the library, whether he regretted anything from his past. He looked at the card that had once told him to start with the foundation, and then, with the calm of a man who had charted a long course from brokenness to steadiness, he said, "I regret things I cannot change, but I have tried to live in a way that makes what I can change worth the cost. He died with friends around him, with papers in order, and with a set of students who would carry some small part of his method forward. The library's shelf kept the primer and the small cards, and the Harrow collection continued to be a place where someone with an uncertain past could find a way in. In time, the story became part of the town's quiet lore. A narrative people told not as a boast, but as a map, a way to show how one man's discreet conviction and insistence that knowledge belonged to all can alter the lives of many. And the worn legal book remained on the shelf, its spine softened by use, its pages marked by marginalia, a small card tucked at the front that read, "To those who believe in second chances." It became, for many, a symbol and an instruction that change is possible, that mentorship need not announce itself, and that the simplest of gifts, time, attention, a book, can be the fulcrum on which an ordinary life tilts toward a new, possible future. Tell us in the comments, who was your anonymous mentor? Rate the story if it moved you.